had a full and fair crack of the whip, and personally that Justice Korean Joseph is wrong, but I believe it's a great victory for Indian judiciary and Indian democracy that hope is kept alive till the end. No country in South Asia and few countries in the world will have such a fair crack of the whip. Justice Joseph is fully entitled to the view there is a bona fide difference between two outstanding judges, and in that process I think we have seen that such issues are not political issues. They are the working out of a constitutional legal process which must be allowed to be worked out. It is in India and India alone perhaps out of very few countries that judges can express this difference at this stage, and I am proud of that fact. I don't believe that the error which Justice Korean Joseph pointed out is a error which should have stopped the execution of Yakub, but that's my opinion and it's irrelevant, because I think this process is magnificently working itself out, giving hope to the most condemned man in the most despicable case. But that is the true vibrancy of our judiciary, the true vibrancy of our democracy. And Karan, I think it's a very slippery slope to keep discussing the merits of this case as several people do on and off. I know you're not doing it, I'm just saying.
But let's not go on to discuss something I'm not discussing. Let's not go on to discuss something I'm not discussing, because I'm not venturing into the merits. But I want to put something to you.
The Supreme Court is final. It is.
Well, yes, but we haven't reached finality as yet.
There's something. One sentence.
Can I Abhishek Singh?
No, one sentence.
If you insist.
Okay.
I want to put something to you. You're making a very interesting point which is worth expanding for the audience. What you're saying is that from your personal standpoint, you don't agree with the objections that Justice Joseph has raised. You think that that personally is not the right stage and point for him to make, that in fact enough has happened legally for the verdict against Yakub Memon to stand. But nonetheless, you also believe, and this is important, that the fact that there are differences between two judges and that they've therefore been given to a higher bench with more judges is actually ultimately the triumph of the Indian judiciary. It's a very interesting, complicated answer you're giving, but it's a very enlightening one.
Well, I firmly and genuinely believe, I have tweeted it today, I know that Justice Korean Joseph is an outstanding human being, and so is the Justice Dave, and I think to be able to show that independence of spirit, that clarity of thought, in the worst cases bring out the best in you. You are not swayed, and I think as long as his view is bona fide, and it's completely bona fide, it's something to be proud of. Consider, Karan, in which country of South Asia would you have this process worked out?
General Anvyas, let me bring you in, because this has now become a problem for political parties who clearly, unlike lawyers, take stands on these issues. And here, there's no hiding the fact that both your government and many of your MPs believe that there is no further room for mercy for Yakub Memon, and therefore these are delaying tactics, to use their colloquialism, rather than legal, legitimate procedures. How do you and how does your party view what's been happening in the Supreme Court for the last 2 days?
Well, Karan, if you ask me, at this stage, the matter is so finely balanced and it is being dealt with by two outstanding judges, as Abhishek was saying. I think it is none of anybody's business to sort of get into these kind of conjectures that it is being delayed unnecessarily. Supreme Court of India is the supreme authority as far as the decision regarding these two conflicting views which have arisen at the final stage of the justice process. That is a prerogative of the Supreme Court, and I don't think anybody should hazard even an iota of doubt on the Supreme Court of this country and their capabilities to deliver justice. So I'm sure ultimately whatever emerges out of it will again, I think we are heading towards a new case history, that in future a case law where you have not included the judges concerned in the curative petition, whether that could be considered as a judgment which will be defective. So I think it in either way it is going to come out with a new case law which will be used for the future arguments.
Mr. Vyas, the very interesting thing about your answer is clearly you don't support the statements or the letters that have been written by some of your MPs, and I won't be nasty and name who they are, but you know and I know exactly who they are. So you don't agree with their positions taken publicly that these are unnecessary procedures, that the process is being unnecessarily dragged on. You're clearly saying you don't agree with that. Have I understood you correctly?
Well, I have nobody to say whether this is right or that is right. I would only say that the dignity and honor of the apex court of the country has to be upheld. You know, who am I to say this way or that way? It's a process. It's under adjudication.
Absolutely. Unfortunately, some of your MPs were willing to say this way or that way about the Supreme Court, its functioning and its procedures. Very carefully, cautiously and wisely, you're not commenting on it. Let me bring you in, Sanjay Hegde, and put this to you. What next? The Chief Justice, I take it, will be appointing a new bench. A larger bench has probably been appointed this evening. That bench will be sitting tomorrow. If that bench were to agree with Justice Joseph that the curative petition has not been handled properly, that there were infirmities in the procedure, will the whole curative procedure have to begin again from scratch?
That would be for the new bench to decide. Tomorrow, the first call that the bench will have to take is whether they can in time hear out the entire challenge
to the previous. When you say in time, how much is that in time?
Before the execution takes place.
Which is
day after. The Supreme Court sits from 10:30 in the morning. Tomorrow they are going to sit around 11:30 because there's reference to a former judge. From 11:30 to 4 o'clock, can they deal with this case in its entirety, or if they cannot, and if they think that the objection is sustainable and substantial and it requires a larger hearing, then there may be an interim stay.
There's a very interesting thing you're saying. First of all, they have to decide whether the objection raised by Justice Kurian Joseph is sustainable. Then secondly, they have to decide whether they can hear the whole thing within 1 day.
It's not an objection raised by Justice Kurian Joseph.
The differences between them.
Yes, it's an objection upheld by Justice Joseph.
And then secondly, they have to look at the matter whether it can be handled in 1 day flat.
Yes.
And therefore, there is a real likelihood that they could end up putting a further stay on the execution because they need more time themselves.
They might need more time.
In fact, Dushyant Dave, it's not just the challenge or the infirmity, or I should say alleged infirmity of the curative procedure and therefore the differences between the two judges that tomorrow's bench has to look into. Presumably, they also have to look into something else. The issue raised by Yakub Memon's own attorney that the Maharashtra government has shown undue haste in issuing a death warrant before the curative procedure was completed. Both issues need to be looked into, presumably, and therefore, can they both be done in the limited time available tomorrow, given, as Sanjay Hegde has just pointed out, that the first 1 hour of the day is lost because of other reasons? Dushyant Dave, can you hear me?
Well, I can hear you intermittently because...
Oh dear, I apologize.
No problem. The answer to your question is...
Go ahead, give me the answer.
The answer to your question. Yeah. Well, I think it is easy to do it tomorrow. I don't think it's going to take much time. And I don't think judges will really, be worried about the fact that the execution is slated for 30th. Because this is a very limited issue which has to be decided by the judges. And I don't think it will require more than an hour's hearing. And which can be easily granted and which should be granted tomorrow.
It's two issues actually, surely. One issue is whether the curative procedure had an infirmity because all the judges at the review stage were not present at the curative stage. That is Justice Joseph's belief. But there's a second issue raised by Yakub Memon's own attorney that Maharashtra showed undue haste in issuing a death warrant before the curative petition had been heard. When you club both issues together, can both be heard in the limited time available tomorrow, Dushyant Dave?
Yes, I think so. Karan, let us understand one thing. Dr. Singhvi might call this a great success of our judiciary, but I personally feel that it is unfortunate that the judicial process is being abused in this fashion by a man who has already been found guilty by 2 courts after detailed hearings. Look, you have to understand that we must respect the human rights of everybody, including a prisoner. But at the same time, you must also respect the human rights of the people who have died and their families. And I think the judges should be mindful of that. It can't be that judges give such a long rope to a man and allow him to raise these kind of technical arguments to frustrate the process of law, which should really result in, execution taking place as quickly as possible, because death sentence has been now held to be constitutionally valid. This was a case which was the rarest of rare case, and if we do not send messages now to this kind of terrorist strikes and the terrorists, then I think we are giving a signal that we are a soft nation. We are really looking like some kind of a, banana republic in this. Not that judiciary's image is going up. I think I disagree with Dr. Singhvi.
But let me put that to Abhishek Singhvi, because the real point I want to put to you, Mr. Singhvi, is do you believe Yakub Memon is abusing the process of law by raising what Dushyant Dave calls purely technical issues, specifically to frustrate or delay the execution of the death sentence when the entire process, including the curative procedure, has been finalized and completed? Is this an abuse of technicalities, or does in fact at the end of the day the right to life and liberty hinge upon the fulfillment of all technicalities? Because justice is not just getting the right result, it's often a question of getting it in the right way as well.
I'll tell you, Karan, why I disagree with my friend Dushyant. The word technicality is very dangerous to use when you are discussing a death penalty case post-conviction. It is common ground that the main trial, the merits are over, the review is over, and the curative is over. Every person on death row goes to court on a technicality, because by definition he is on death row and about to be executed only after the merits are over. So any non-merit argument, if you call it technicality, all reviews and more so curatives are technical. Point one. Point two, our system is based on the fact that because it is the rarest of rare and it is the extreme irreversible punishment, the so-called technicality is not a technicality. Every possible inch and millimeter has to be explored to make sure that you don't send to the gallows one innocent man, even though you might acquit several guilty ones. Now, that being the principle, I myself started by saying that I believe that Yakub has got a full, comprehensive, fair crack of the whip and therefore should hang. But I am proud, as Voltaire was, that he is getting his full chance, and that chance is being wrongly characterized by my friend Mr. Dave as a technicality. He is getting a chance. Just consider, 1 out of the 2 judges, 50% of the Supreme Court thinks it's not a technicality. There is a point, there is a passage in Hurra which says that the same judges should be there at least. Now, I disagree with that, because I believe that even if the same judges are not there, it has not caused any miscarriage of justice. But that is for the next man to decide, because 2 are differing. And for a man who's about to hang on Thursday, that's not a technicality. Okay. What is the victory of the judicial process? When Indira Gandhi died, Karan, not one person in this country, not one child thought that all 3 should not hang. All 3 were sentenced to death by the trial court. 2 were sentenced to death by the High Court. 1 was life sentence. In the Supreme Court, 1 was acquitted. It's only because the so-called technicality, our Supreme Court doesn't get affected. Now, not one person thought that the man who was acquitted on 31st October 1984 was not guilty.
Absolutely.
So I think this is where a liberal democracy's ethos are very different from different kinds of countries. I know the emotive argument. Do you think I feel less for the victims? In fact, I am one of the ones who started by saying I believe he has got his just deserts. But this is a proud legal process, and no country, very few countries on this planet can boast of such a proud, even USA has failed Guantanamo victims many times, and I think we have something to be proud of.
General Anvyas, I want to bring you in here, because actually the argument that you heard from Dushyant Dave is very much the logical foundation on which many of your MPs have been complaining that the Yakub Memon defense team is dragging out the matter. It's laying stress on technicalities. This is an attempt to frustrate the execution of a death sentence, which by now should have been executed. What Dushyant Dave has done is to give a sort of jurisprudential foundation to the arguments made by your MPs. On the other hand, your own position is almost articulated by Abhishek Singhvi. He's given a sort of logical, philosophical foundation to your original statement. Once again, I want to ask you, as a party, which of the 2 lawyers' philosophical outlooks do you stand by?
Well, Karan, let me tell you, first of all, I have the highest regards for both my friends. They are eminent lawyers. I am not a lawyer, and therefore, what statement I make is as a layman. I would simply feel that, this is the last resource. This is the last time that one gets an opportunity. If something is done wrong and at a later date if it is found there is no remedy to correct it. And therefore, you know, the difference between a barbaric state and a state like ours is that even if we feel emotionally that this is the way and this is how it should have been done, you know, ideally then the fellow should have been gunned down there and then where he was found. But that doesn't happen in India. There is a system and whether we may agree or not, we have to accept that the system is a system which follows liberal, democratic and legal process. And therefore, I will tend to agree with Abhishek Singhvi in this matter.
I am going to applaud and congratulate you, which is something I don't normally do for politicians, but I will applaud you on the grounds that you have taken a stand that differs with that opinion of your MPs and many of your ministers. And I applaud you because you're saying this is the last chance a man who's condemned to death has. Let him have it, because only then can we say he had every opportunity fairly and squarely, and if there's an element of delay, so be it. It is better to be liberal and end up perhaps infuriating some because of the delay rather than to be hasty and run the risk of being wrong. We're going to take a break at that point. When we come back, we're going to turn to the other question that many people believe the Supreme Court needs to ask itself. Were there mitigating circumstances that weren't brought to the attention of the court, as B. Raman has alleged in a recently published article, and do those need to be now taken into account before the sentence is finalized? We'll be back in a moment's time. See you after the break. The point, we're discussing the Yakub Memon case. Sanjay Hegde, let's come to another issue. A former Supreme Court judge, Justice Harjit Singh Bedi, has said that the Supreme Court should take suo motu notice of B. Raman's article, which claims that there were mitigating circumstances that should have been borne in mind when Yakub Memon was sentenced to death, but were not communicated to the court. Do you believe that sort of suo motu notice is now possible and should be taken?
As the law currently stands, there is no provision for it. And if this information had come out pending the appeal, for instance, then there could have been further evidence led. At this stage, if it has to be taken on, some new innovative procedure may have to be devised if the judges are so minded.
What about the should question? Should it be devised so that it can be taken on?
See, this is a voice from beyond the grave. The credibility of the voice, and whether there will be any evidence apart from this article, that also is an open question. I am not a hanging man myself. Left to me, I would have probably looked for some device. But I am also a man of law. I am also a man who believes that the law has to be followed as is laid down by the legislature.
And therefore, this is not the right device.
And therefore, at this stage, this is too late. But nothing prevents the government from looking at it, looking into its files, seeing whether there is any evidence.
But the government is a different stage. Let's stick to the Supreme Court. You're now moving to the government. Let's leave the government out of it. Abhishek Singhvi, yesterday in an interview to this very program, Ujjwal Nikam, the prosecutor at the trial stage of the Yakub Memon case, freely and readily admitted that A, he was not aware of the mitigating circumstances that Raman has written about, and then he went on to add, therefore, he had not made the court aware of those mitigating circumstances either. Those two facts being the case, does it strengthen the grounds for the Supreme Court taking suo motu notice of B. Raman's letter, or does it have no bearing on it whatsoever?
No, it does not so strengthen it. What I am going to now say, since you have now come on the slippery slope of merits or partly merits, is fully consistent with what I said earlier. You know, Karan, the Supreme Court is right because it is final. It is not final because it is right. You cannot allow this slippery slope to open on the merits front. I can give 5 arguments this way, you can give 5 arguments that way. For example, why did Mr. Raman not intervene in the Supreme Court proceedings with this? Why was this not placed and tested? You know, a simple intervention application would have done it. If you open this kind of a thin end of the wedge, there cannot be finality, and public policy, judicial policy places a lot of value on finality. That's why they say the Supreme Court is right because it is final. It is not final because it is right. I think this kind of argument cannot be allowed. In fact, the only arguments open to a condemned man at this stage are what Dushyant calls technical, but which are important principles of law, which if violated, procedural justice, procedural safeguards, they can be open, but not substantive merits at this stage, because there is no end to it. And for every Raman this way, there are 5 other arguments the other way. This really should have come into the domain of the adjudicatory matrix. It can, at the best today, and I'm not saying it should, at the best today be part of a remission, mercy, extraordinary executive discretion process, which comes up at the very last stage at the governor or the president's house, that look, there is a grave miscarriage of justice, but it cannot be part of an adjudicatory matrix in the apex court.
Dushyant Dave, let me quote to you what Justice Bedi, who was also on this program yesterday, said in defense of his demand or his suggestion that the Supreme Court should take suo motu notice of B. Raman's letter. He said at the end of the day, it was a man's life that was at stake. If it is generally the case that information available today was not available at the time of sentencing, then review the sentencing. And he's not raising any questions about Yakub Memon's guilt. He's only saying it's a question of sentencing. A mere technicality or a mere procedural concern shouldn't stop you raising that issue now. How do you respond to Justice Bedi?
Well, with great respect to Justice Bedi, who was a very fine judge and very sound in criminal law, I would say that he's completely wrong. There is no scope in law for entertaining any such evidence at this stage, any such argument. There is finality, and that finality has finally been attained, not only with the dismissal of the appeal, but with the dismissal of the review and the curative petitions. So I think this kind of an argument, if it is accepted, it will really lead to mockery of justice, because every day in all kinds of cases people will come up with new evidence and say that this was not produced before the courts below. So I think it would not be done, even if the man's life is at stake, because you have to look to the other overwhelming evidence which is available, and that is the involvement of Mr. Yakub Memon directly in the conspiracy. Maybe he didn't execute the acts, but the conspiracy, and including parking of the explosives in his house, and facilitating the transportation of that.
Can I stop you there for a moment? Can I stop you? You see, when you refer with such detail to the evidence against Yakub Memon, you give me the impression that you're actually talking about guilt. No one is questioning Yakub Memon's guilt. What in fact Justice Bedi is saying needs to be re-looked at on the basis of B. Raman's letter is the sentencing. In other words, whether in fact in these circumstances, given these mitigating factors, the death sentence applies. So the evidence against him surely shouldn't matter at this point. What matters is, were there mitigating factors that could commute the death sentence to life?
Well, it's a word of Mr. Raman against everybody else. If at all this argument was to be accepted, it should have been fairly told by the prosecution to the trial court, the Tada court. And I think if they didn't do it, maybe there was no such really, facilitation by Mr. Memon to the investigating agencies. So the case of the investigating agencies is that they have nabbed him from Delhi, and that he really didn't help them.
Dushyant, this is Sanjay Hegde.
I don't think anybody should go into it.
Dushyant, how do you always trust the investigating agency to tell the prosecutor the right thing? Here, Mr. Raman was in charge of the operation. Mr. Raman was such a civil servant that he kept his mouth shut, but he was so upset about it that he wrote it down. After he died, the thing has come to light because his brother has authorized it. Now, this is an unusual case.
Well, Mr.
This is
Raman,
unusual.
No, Mr. Raman should have appeared.
If he doesn't,
he should have filed affidavit.
And he's dead.
Can I interrupt on one thing? The debate between Sanjay Hegde and Dushyant Dhawan is over this simple question: why didn't B. Raman make this knowledge available to the court during his lifetime? Can we rely on it now that it's become public after his death?